Welcome to my channel where we discuss everything and all things politics, especially about the 2023 presidential election that was held in Nigeria on February 25, 2023. As you all are aware, the outcome of that election, in which Alhaji Tinubu was controversially declared the winner of the election on March 1st, is now being challenged at the highest court in the land, the Supreme Court. And the Supreme Court started sitting on Monday, October 23. And there was an interesting development that came up that is the essence of this video. This is because at the sitting at the Supreme Court on Monday, the Supreme Court said that there are conflicting letters from the Chicago State University on President Bola Tinubu's certificate, that there were conflicting letters from the Chicago State University on President Bola Tinubu's certificate. Justice John Okoro, chairman of the 7-member panel, hearing the application of Atiku Abubakar, the presidential candidate of the People's Democratic Party, filed against the victory of President Bola Tinubu, said this on Monday. So this was a statement by Inyang John Okoro. As I said earlier in the introduction, the Independent National Electoral Commission had controversially announced Bola Tinubu, the presidential candidate of the APC, as the winner of the February 25 presidential election. And why do we say controversially? Because the chairman of the Independent National Electoral Commission was reminded of inconsistencies in the tabulation of the results and other complaints by the major political parties. And he said at the National Conference Coalition Center, at the International Conference Center, that they are going to look into this matter. At the end of the day, the man did not look into the matter. He went ahead and announced the result and told those who are not satisfied to go to court. Nothing could be described to be more controversial than that. But the same INEC was able to delay the results of several other governorship elections in Nigeria. But that presidential election, there was so much rush to get it announced, even in the middle of the night. So that was why we keep on insisting it was a controversial announcement. They didn't wait to hear out the complaint by the PDP and the Labour Party and others on their observations before the Independent National Electoral Commission chairman rushed to announce that result, in which Bola Tinubu was the major beneficiary and the APC. Now, because of that controversial result, the major contenders, Peter Obi of the Labour Party and Atiku Abubakar of the PDP, they headed to the Presidential Election Petition Court. And we all know that the Presidential Election Petition Court struck out the appeals of Atiku Abubakar and Peter Obi, which made Atiku to head to the Apex Court. Atiku and Peter Obi to head to the Apex Court. And Atiku asking for extra evidence He asked for extra evidence when he went to Chicago State University to get more information on Tinubu's certificate from Chicago. So at the Supreme Court yesterday, Atiku was asking, to file extra evidence against Tinubu on the alleged forgery. Atiku has sought the academic records of Tinubu, and he has gotten it. And he wanted to use it to prove his allegation that the president submitted forged documents or forged certificates to the Independent National Electoral Commission. However, it was alleged that by the time the documents were released, 180 days statutory period within which an election petition should be filed and determined had elapsed. But Atiku at the Supreme Court yesterday asked the court to grant him his appeal to tender fresh evidence given the nature of the issue. However, this didn't go down well with Tinubu and his lawyers, who kicked against this, saying granting such will amount to abuse of court process. Atiku predicated his plea on ground that presenting forged documents by any candidate, especially by one for the highest office in the land, is a grave constitutional issue that must not be encouraged. But Tinubu kicked against this, arguing that the issue is a pre-election matter, amongst others, and subsequently prayed the court to deny the grant of the application. While faulting Tinubu, Atiku submitted that the issue of merit ought not to be determined or pronounced upon at the interlocutory stage. Atiku also pointed out that the presentation of a forged certificate disqualifies a candidate for all time, no matter when presented. Now, speaking at the hearing on Monday, which is the main issue we are discussing in this video, Justice Okoro said criminal matters have to be proved beyond reasonable doubt. Now, Justice Okoro is admitting that forgery allegation against Bola Ahmed Tinubu is a criminal matter. But what he's saying is that being a criminal matter, Atiku Abubakar and his people must be ready to prove the allegation beyond reasonable doubt that Tinubu committed forgery. And then he came up with a very strong and very controversial statement after that, after saying that criminal matters have to be proved beyond reasonable doubt. He went on to say, now I'm quoting him again, he said, but in this case, there are two conflicting letters from Chicago State University. One authenticating the president's certificate and another discrediting it. Which do we rely on? Which do we rely on? That is what Justice Inyang Okoro asks. Which do we rely on? He said there are two conflicting letters from Chicago State University, one authenticating the president's certificate and another discrediting it. When I first heard this, I was shocked about this because I followed the court process at Chicago State at Northern District of Illinois in Chicago, where Atiku Abubakar's petition was heard, his, his subpoena application to compel Chicago State University to release Tinubu's academic records. I saw several times where the Chicago State University stated it clearly that they didn't know where Bola Ahmed Tinubu got the certificate he submitted to the Independent National Electoral Commission, which to me is the major issue of contention. Now, there were issues of whether Tinubu was their student or not. They said that Tinubu was their student, that he got admitted, that he graduated. But even that is doubtful, because if you go through the Tinubu's record, he still have some outstanding courses to take that he has not taken yet from the record that was released to Atiku Abubakar. Yet they say he was their student, he graduated. How could he graduate when he has outstanding courses? Unless if American education is a total mess. Because in this country, Nigeria, and the United Kingdom, you cannot graduate when you have outstanding courses to take. It's not done anywhere. But that is by the way. Now, if you see the lawyer of Chicago State University, Michael Hayes, severally he asks the authorities of Chicago State University whether they can, under oath, authenticate the certificate that Tinubu presented to INEC. They say they cannot. Even though they acknowledge that he was their student, he was admitted to their school, and that he passed out, and he graduated. So they say they cannot authenticate that certificate. Now, if they cannot authenticate that certificate, from what we saw from the proceedings of the court and even at the deposition, so how could Chicago State University still write a letter that they authenticated to authenticate Tinubu's certificate? Ordinarily, I would have expected the lawyers of Atiku Abubakar to demand for that letter that was supposedly written by Chicago State University authenticating Tinubu's certificate. They ought to demand for it. Even though it's a mere letter, which ought not to have even be compared to a deposition, which was done under oath. But for the fact that the Supreme Court said they have a letter from Chicago State University, what should be paramount ought to be to demand for a copy of that letter. Because the news media had been silent about this. What was the reaction of the Atiku Abubakar team to this information? Did they demand to see this letter that was supposedly written by Chicago State University authenticating the certificate? Because in several instances, the witnesses of Chicago State University in the court that was presided over by Justice Gilbert, the one by Nancy Maldonado, and everything, none of them ever agreed to authenticate the certificate. So how come Supreme Court of Nigeria has a copy of authentication of a certificate? So that ought to be one issue that needs to be addressed, to see a copy of that letter that they had. Now, that is by the way. Now, because they said that such a letter existed, Justice John Inyang Okoro asked which document should be accepted as superior. Literally, that's what he was asking. Which one do we now believe? We have two letters. One saying that Tinubu certificate is authentic, another saying it's not authentic. So which one do we follow? That's what the Supreme Court Justice is asking. Which one do we take? And you know, when a matter reaches this kind of technicality, it becomes very troubling, especially when you are pressing to remove somebody who is already in power. And you have this kind of conflict in terms of perception from the justices of the Supreme Court that ought to be the final arbiter on the matter. Now he's asking for your opinion, or for the opinion of the parties, sort of. Of course, they are the one the Supreme Court are the one to take the decision. But he raised that question. That question is ominous. I can tell you that for free. That question is ominous, and is troubling. Now, having said that, let us look at the issue of a letter and a deposition. Let us assume, without conceding, that they have a letter that Chicago State University, after all the things they said in the court of Gilbert, or George Gilbert, Jeffrey Gilbert, and what they said in Nancy Maldonado's courts, that they cannot authenticate the certificate that Tinubu presented to the Independent National Electoral Commission. Let us assume that the letter went back on their own and sent a letter to the Supreme Court of Nigeria, different from what they said in open court about the certificate. Now, between a letter by Chicago State University, a mere letter, and a deposition, which one should be more authentic? Because a mere letter is different. A mere letter, like to whom it may concern, is different from a deposition that is made under oath. Okay? It's just like there is a debate about the age of somebody, and his father wrote a letter to whom he may concern that my son is 16 years old. This is when he was born. Would that be acceptable more than perhaps the mother sent another certificate, this time affidavit, showing that the son is 18 years old? I think legally, the one that will be binding will be the one that was submitted by the mother, which was a sworn affidavit. Therefore, a mere letter from Chicago State University and a deposition that the university made in court or anywhere they did it is far more important and more significant to the subject matter than a mere letter, to be frank. And it is surprising that Justice Okoro was asking about the difference between the two of them, because he was weighing them to be the same. Because from the question, you can see that he weighed both the deposition and the letter from Chicago State University, that they are the same thing. So which one do they take? Which one would they take? But one thing that is clear is that Judge Jeffrey of Illinois courts and Judge Nancy Maldonado, they understand the enormity of what Atiku was looking for. Because from the beginning, knowing the importance of the discovery Atiku Abubakar was seeking to get to help his case, they had insisted that whatever documents that Chicago State University will provide to Atiku Abubakar must be deposed under oath. And that was to grant Atiku undeniable, to grant Atiku and this, whatever certificate he's bringing, undeniable authenticity. Okay, because it was to avoid this kind of questions by the Supreme Court. That was why Nancy Maldonado and George Jeffrey, they insisted that the documents that Chicago State University must release to Atiku Abubakar must be deposed under oath. Whatever they are saying must be under oath. Because before they were prevaricating on this matter, speaking under oath. But these judges insisted they must do that. They must speak under oath. And the essence was to ensure that there will be no doubt about whatever was gotten by discovery from Chicago State University. But now here we are. A judge of the Supreme Court is asking which one is more relevant, a mere letter and a legal deposition from the same source by the same institution. Now this is like asking which is more authentic in the proof of paternity, a father's name recorded in the birth certificate or the DNA, which is more authentic. How do you prove paternity? Do you prove paternity by the father's name in the birth certificate or by the DNA? In this case, we are talking about deposition under oath and a mere letter. The deposition that Atiku came back with should be given more priority and doesn't require any argument on which one to be given more priority, a mere letter or an affidavit. Of course, since this is a legal matter, an affidavit carried more weight, because if you lie under oath, you pay a price for it. That was why even the Chicago State University witnesses, when they appeared during the open court in Chicago, they were very careful to say they will not speak under oath. But when they were compelled to speak under oath, that was it. That was it. That was the smoking gun that Atiku Abubakar was looking for them to, under oath, deny the certificate in Abuja. And that was what they did. They said they don't know where the registrar of that university, the registrar was clear, Caleb Westberg, was clear. So we don't know where he got that certificate. It's not from us. When pressed further, he said that he could have gotten it from anywhere, from online. It's not from them. You can go and read the deposition. It's in public domain now. Just Google it. You can go and check it out. Take your time and read the deposition. So how could Chicago State University, after swearing under oath, depositing under oath, that they don't know where Tinubu got the certificate, turn around to write a letter to say that the certificate, they now know where it is that it is from them. Because to authenticate means saying it is from us. But go and read the deposition, which is in public domain. You hardly see anywhere where they claim that that certificate was from them. Now, this question has led many to begin to express fears. If you go online and everywhere, a lot of people are expressing fear that, look, uh, technicality is going to be a major issue in this matter, and that technicality could be used to achieve the purpose of those who are, you know, that the Supreme Court want to use technicality to be the overriding force in this matter. But it's also interesting that at the inauguration of the Presidential Election Petition Court, they did insist, the chairman of that panel said that technicality should be avoided, that the law should take precedent over technicalities. But you can find out that even in their own judgment, it was all about technicalities. And even Supreme Court's rulings on 25% in Abuja were all disregarded and not mentioned at all. And technicality was used to ask you what is the difference between Abuja and other states. You know, it was a huge embarrassment to many Nigerians and even the international community when that Presidential Election Petition Court said that what was indicted was Tinubu's bank account and not Tinubu himself. Okay, it's just like somebody shooting a gun, killing somebody with his gun, and he said that it is the gun that killed the person, that is not the owner of the gun that fired the shot. The gun fired itself. But anything goes in Nigeria. That's why Nigeria is where it is today anyway. Now, one of the important takeaways also yesterday was that Justice Inyang Okoro acknowledged that the oral deposition, which indicted Tinubu on that certificate matter, because when Inyang Okoro said that one authenticated the certificate and one did not, it means he was talking about the deposition in which the Chicago State University said they don't know where Tinubu got the certificate he presented to the Independent National Electoral Commission. So that should be something of a cheering news for Atiku Abubakar and his legal team. However, the important thing to take away from this, the most important thing is that this matter has now gotten to the level where the Supreme Court has the final say. It has gotten to that level. Nigerians have to pray that the justices of the Supreme Court, at least having accepted having received the evidence that Atiku Abubakar brought, that they will act according to the law of the land, and will not allow technicality to overshadow their sense of legal understanding of the matter. That's what they should pray to God. That's what Nigerians should pray, that technicality should not be used, that they should not rely on technicality to arrive at the verdict that they will deliver at any time. They will do it between now and November 6th. Let technicality not be the issue, because if they use technicality, well, the verdict they will give may not be pleasing to most Nigerians, but they will have to live with it for the next 4 years. But that is what it is. But the major thing, as far as I'm concerned, the victory for Atiku and his team and those who support them is that at least Atiku Abubakar had been able to present the discovery that he made in Chicago, and the Supreme Court has accepted it. Whatever they do with it is now left to them and their conscience. Thank you for watching this video. And if you are new to my channel and you have not yet subscribed to my channel, please subscribe to my channel. Hit the subscription button, hit the notification bell. When you subscribe to my channel and hit the notification bell, anytime I have a new video, you'll be among the first to know. God bless you. And please don't forget to like this video, because when you like it, Google will rank it high and recommend it for more people. Thank you, and God bless you and yours.